All right, now, in this fourth and final session, our working title, Constitutionalism, and I'm going to check on what it is. The exact thing, it's to do with institutions, so I just can't make it up. Yeah, Constitutionalism and institutions, that's an easy enough title. And what I want to suggest here is that, well, let me rephrase it. What is a constitution supposed to do? It's well known that a constitution is not supposed to be the same as a statute, and that you can have a statute very, very long, very, very complicated, and if it's not in the statute, then you know you haven't done anything wrong, or something like that. A constitution, at least the 1787 folks, and perhaps all the way through to the 1840s when new constitutions were being written with new states entering into the Union, they were generally short in length and stated outlines and purposes and procedures. I mean, we've got the preamble which states the purposes, and then it got Article 1, the legislature, and on you go. But they don't go into incredible detail, whereas a statute does go into incredible detail. And it goes beyond institutions. If you compare the 1849 California Constitution, which tends to be short, with the revised, improved one of 1879, a mere 30 years later, called by the progressives to write a new constitution to meet the new circumstances, you will find that it is at least 3 times as long and 3 times as detailed, going into incredible detail over education, etc. So we've got, in which they're not particularly interested in the institutional framework, but more interested in the, what I would call the administrative apparatus of doing things. In fact, Woodrow Wilson this is really fascinating for me, in 1887, 1888, at the 100th anniversary of the Constitution, Woodrow Wilson, then an intellectual, scholar at Princeton and other places, Virginia. And then he became president of Princeton and then went into politics. He wrote a very, very influential piece on public administration, in which he said that Americans have, on the whole, paid too much attention to constitutional design, constitutional institutions, and not enough attention to governing or administration. What we need are enlightened administrators to run the show. We no longer need to be fussing and bothering about separation of powers. And it is well known that you can see this shift. I mean, it's well documented. You can see this shift, what a constitution is supposed to do. Namely, lay out the institutional framework with the purposes, let's say 1787 to 1849, and then this new approach, which is to write everything into a constitution or nothing into the constitution. So that the constitution either becomes overpowered with minutiae and detail, or you can ignore it and just rely on administration. This is a fundamental change. Woodrow Wilson, it is well known, spent a lot of his time joining clubs during his time as both a student and a teacher. And when he joined these clubs, the first thing he'd ask for, well, like a fraternity or this club or that club, he'd join in, the first thing he'd ask for is, can I see your constitution, please? And he'd get the constitution and he'd go through it and say, when was this written? It was probably 25, 30 years ago. He says, we need to update this constitution to meet the new times in which we're located. It usually turned out to be 2 changes. One, overpowered with detail to meet the new circumstances, or we can do away with it. And I think that's one of the themes I want to sort of talk about in our last session today. Constitutionalism and institutions. Let's begin with Federalist number 9. At Federalist number 9, what I've done here is to provide a brief outline. There are certain numbers in which I provided you with a paragraph by paragraph outline. Others I've just provided with a brief outline. Again, this is not supposed to be a cliff notes, not supposed to be a substitute. I want to encourage you to go deeper, and I found that the best way to encourage people is to provide them with a little sort of a helping hand and then help you into the text. The claim in Federalist number 9 is that those who criticize democratic republics, representative government, governments based on the consent of the people, those who criticize the history of such institutions are correct. Their life has been nasty, poor, brutish, solitary, and short. They've been correct. And if we hadn't found new ways to combat this swift and nasty decline, we couldn't boast that we're going to do something new and honorable in the new world. Fortunately, we have discovered improvements in the way the art of government, the science of politics, constitutional making, institutional design. We have found 5 improvements, which is now going to make it possible and desirable to defend the case for liberty. Because the case for liberty before was actually a cover for the case for license and mobocracy. But we're going to make it defensible. We're going to have liberty and order. You say it's order or liberty, we say it's order and liberty. That's our claim. How are we going to make that work? First of all, we're going to introduce something called checks and balances, which means actually legislate. That's the precise meaning of checks and balances is bicameralism, 2 chambers. So that we're going to divide the branch, we're going to divide Congress or the legislative branch into 2. So you're going to have what they call a first branch and a second branch. Now this is known before. Britain had House of Commons and House of Lords, but it was clearly to represent the common folk and the lordly folk. America's claim is that we're not going to represent the common folk and lordly folk in 2 branches. We're going to actually represent the people 2 different ways. And you say, but that's novel. And the answer is yes. Where do we see that today? And the answer is virtually everywhere except 1 state. If you take California, for example, we have 80 people in the Assembly, the first branch, and 40 people in the Senate, the second branch. There's no particular, I mean, for the last 50 years anyway, there is no particular interest in the last 50 years of representing counties or precincts or parishes or anything other than people in the Senate. It's just that we, the people, are represented in 2 different ways. We're represented in a first branch in smaller constituencies and in a second branch with larger constituencies. In the first branch, we're represented for 2 years. In the second branch, we're represented for 4 years. So what America's introduced institutionally and constitutionally is a different way of the doctrine of 2 chambers. The previous way, the ancient way, the normal British way was 1 chamber for the lower class, the second chamber for the upper class. The way to get decent politics is to have the 2 classes agreeing. The American way essentially is to have the first branch represent the people in smaller constituencies for a shorter period of time, and the second branch represent the people in larger constituencies for a longer period of time. What is that supposed to do? As we shall see as we get into this, that means what is the peculiar role of the Senate or the second branch? And the answer, again, as we shall see as we move along, the job of the second branch is to introduce the cool and deliberate sense of the community. That is it possible, because of faction, because of human nature, what we did in the last session, is it possible that from time to time human beings will gather together, might lose their cool, might become slightly intoxicated, prejudiced, and foolish, and pass legislation or engage in actions which they might later regret? The answer is yes. And the easiest example that I like to use is you go to a party and you behave at a party in a different way than you behave alone. Madison is one of the earliest observers of what happens when you get people together. They try to impress, they try to belong. If you talk one-on-one with a person, you might get some reasonable answer. You talk to people in a group, all of a sudden you have group reinforcement, peer group pressure, and people behave differently. And so if you go to a party, you want to impress, so you do something and you drink too much. Not that any of us would ever do that. But some people do. And they do that from time to time. They drink too much and they say, I'm going home. And your friend says, no, you're not. You're not going to drive home because you might hurt yourself and hurt others. I am a free and independent person. I will do whatever I want to do. Get off me. You are being controlling. After all, it is my car, my life, and my keys. And you say, I'm your friend. Well, if you're my friend, you will do what I want. No, I'm your friend, therefore I will do what I think is good for you. Oh, a progressive in my midst, are you? And you say, no, just a temporary one. That is, what I recommend is that you sleep on the couch, sleep it over, rather than sleep in prison. Sleep on it, and then when you come back to your senses, which isn't going to be too long, because booze goes through you, and you might wake up with a little headache, but you're fine again until the next night. So that if you manage just to sleep it off a bit, then you'll be fine. And you'll drive home and it'll be fine. Oh, so you're only being a temporary progressive. Yes. Okay. I think that's what Madison has in mind. That a friend of a republic, a friend of a democratic republic, is not one that lets the House and the people, when in a fractious, intoxicated mood, get exactly what they want whenever they want it, because they'll probably regret it the next day. Like a lot of folks regret, I wish I didn't say that, I wish I hadn't done that, whew, I hope I get away with it because I'll never do it again. It was a one-off. And so what Madison is doing is, by introducing bicameralism, is not introducing two classes of representation, but introducing the notion of sleep on it. He's not putting a stoplight, he's putting an amber light. Slow down, think about it. And if you feel the same way tomorrow, go ahead. Is that undemocratic? Is that anti-democratic? That is the criticism that Madison and constitutionalism has received. Anything that resists the will of the majority is known as built-in anti-democratic nature. And I think that's the real challenge. That Madison will respond, a friend of democracy will be directed to the potential ills and drawbacks. And therefore, is it possible, because think about it, just let's use the word democracy for the moment. To create a democratic arrangement is not necessarily the same thing as creating a decent arrangement. Creating a decent arrangement is not necessarily the same thing as creating a democratic arrangement. Can we be both decent and democratic? That's the challenge. But how do you create decency? Particularly, if we think about the last session, that people are not necessarily born with an abundance of decency. Institutions help. That is, if we can channel people to say, sleep on it, slow down, think about it. Don't make a rush to judgment. Keep away from the email. Don't hit delete, don't hit send everyone. Right? Control yourself. And if you cannot control yourself, how happy is the day that, that the electricity went off just as you were about to say send. I think you get my point. My point is it possible to have built-in speed bumps, built-in sort of restrainers, without at the same time saying, oh, you've introduced non-democracy? And current democratic theory seems to suggest that any speed bump is somehow an anti-democratic move and demonstrates the aristocracy of the framers. Well, that's what you have to deal with. Is constitutionalism itself anti-democratic? There's a certain element from FDR on that thinks, and this is where Ronald Reagan's rhetoric is so incredibly wonderful, but I'll get to that in a minute. For FDR and Teddy Roosevelt and a lot of the progressives, and all you have to do is to go into the National Constitutional Center in Philadelphia and you will see it. The three most important words in the Constitution for the progressives are "we the people." And what does that mean? It means the Constitution means whatever we the people say it means. Have you read the elections? Ronald Reagan understood the powerful rhetorical impact of the phrase "we the people." And so he turned it to say, in our Constitution, we the people tell the government what to do, rather than the government telling what we the people have to do. I think one of the most interesting things that you could do with the help of the Reagan in your schools and whatever, is to compare the rhetoric. And again, I don't mean propaganda, I don't mean lies, I mean rhetoric in terms of being able to express the American way in terms that Americans understand. It's to see the parallel rhetoric for different purposes between FDR and Reagan. All you have to do is to take a look at their two. Reagan had the opportunity to deliver the 200th, the Constitutional Day address on the 200th anniversary of the signing of the Constitution. FDR had the opportunity to deliver the Constitution Day address on the 150th anniversary of the Constitution. It's always been one of my sort of ideas that one day I would compare and contrast, since I'm not going to be here for the 250th anniversary, that to deliver a sort of a compare and contrast and see what, and I mean, because I think those are the two foundational constitutional interpretations that we have. And Reagan understands you have to go with the people, you have to have that populist understanding in order to, and Reagan in this period of time was known for saying Americans have a rendezvous with destiny. That's an FDR phrase, the whole idea of the rendezvous with destiny. So I think that is extremely important. Reagan used "we the people" in a different way than FDR used "we the people." FDR used "we the people" as a way as we don't have to look upon the Constitution as institutional restraints on the government. Reagan looked upon "we the people" as giving the Constitution an institutional restraints on the government. And I think I say that in a different way. For FDR, to the extent the Constitution matters, he says, imagine the American people in a chariot. And you have three horses. Those are the three branches of government: the Congress, the President, the judiciary. What we have in the 1930s, says Roosevelt, is that you have the Congress horse going one way, the President horse going the same way, the Supreme Court horse going a different way. What we need is coordination between the branches. That's a rather odd way of understanding separation of powers. If we look at Madison, the whole point of the separation of powers is not to be described by the horse and carriage metaphor. It's to be understood by ambition counteracting ambition. It's the danger metaphor, it's the war metaphor, that in terms of balancing and checking. And I think Reagan understands that same thing. So I'm trying to show you that this idea of constitutional institution, which we're looking at in this final session, has repercussions in the 20th and 21st century. Obama is, the students, 23-year-olds, 25-year-olds at Pepperdine graduate program. When I talk about Bush's deciding that what he's going to sign and not sign, and what he means by what he doesn't mean, I say, where is that in the Constitution? And the answer, of course, it isn't. So therefore, you have to interpret it. Where does it say that because Obama has a pen, he can do whatever he wants? It doesn't. But what has happened ever since FDR, it seems to me, is that we've interpreted constitutionalism as what the court and the president say it is, rather than the institutional framework which it is supposed to outline. And so Congress, in this model, comes over as an obstacle. or that Congress's job is to provide the funding. So my students are upset at Congress because they are blocking the way of a we the people president. And that really, and it's not, I just think, a love or a dislike of Obama. What we have done is abandon, in many ways, the improvements which Federalist 9 claims to have made. And that we're looking towards a streamlined administrative form of government which decreases the importance of institutions and increases the attachment to a person, the president himself, and increases the attachment to presidential elections. Now, to go back to Federalist number 9 a moment, bicameralism is an improvement, and I've shown you some ramifications of that. The separation of powers, which we've just gone through, between the president and the Congress, is a second improvement. In Britain, for example, they have a prime minister, so there's no separation of powers. America claims by separating the president from the Congress, we have led to improvement. Fundamental criticism, that introduces dysfunctional government. That is a major criticism of the Constitution and institutionalism today. Third improvement, an independent judiciary. In Britain, they've only now approached the independent judiciary. But the question is, how independent should the judiciary be? And independent of what? And of whom? Hamilton, the 78th Federalist, says the judiciary can be independent because it is the weakest branch. It's the branch that has to rely on Congress for its structure and on the president to enforce its laws. The judges will be tied down by precedent and therefore will not be dangerous. Anti-Federalist Brutus said, if you let the judges interpret the Constitution, they will make the Constitution whatever they want it to be. The fourth change that Madison and Hamilton suggest is that we will introduce representative government rather than direct democracy. And the fifth change is we will have an extended republic rather than a small republic. These 5 institutional changes, which are written into the Constitution, are supposed to make America successful where other countries have failed. That is why the American journey is called an experiment. It has never been tried before. How do we know whether the experiment is working or whether the experiment is failing? The answer is, it seems to me, the following. Are the people attached to the Constitution and institutions, or are they attached to outcomes? For example, if the federal government is willing to pay for school lunches and say, school district, we will pay you for school lunches if you serve at your school lunches a vegetable, a fruit, and something else, and they have to eat that, otherwise you don't get funded. What do you do as a local school district? Do you say yes? After all, it's about the children. Or do you say, no thank you, it's about local control? The answer is, most school districts say, thank you for the handout. And then what are we finding? Even the LA Times has disclosed that every day at least $110,000 of food is thrown in the trash by we the students who don't want a vegetable and a fruit being told to them, being provided for them by taxpayers' money. What bothers me is that I'm paying for them to throw away the food. And then the food can't be given to the poor because of lawyers wondering about what sanitation program has been violated. So we can't even give it to the poor, although we're going to work on that through the administrative state. The issue that I want to sort of end on, so we can have a good 15 minutes of discussion, is, are these institutions still important? Our current approach seems to suggest they're less important than they used to be because human nature has changed. that we can now become angels, or we can transform ourselves in such a way that we do not have to rely on these checks and balances. We do not have to rely on these separation of powers. That what we want is effective administration. That seems to be what we're getting at. And I don't know that is accurate, whether it's Woodrow Wilson's 1887 speech, that politics needs to be replaced by administration, or that it's that political parties now try to overcome the separation of powers. So I'm concerned about the role of institutions. I see, for example, today, that senators are much more interested in becoming Secretary of State than they are being senators. I find that rather odd, that both Hillary Clinton and John Kerry are very willing to give up from being a U.S. senator to being a Secretary of State. I mean, that seems to me to be a bit odd. Barack Obama, all right, I can see President of the United States rather than Senator. Senator McCain rather being a president than a senator. What is it about being in the administration, in the executive branch, that seems so much more interesting, powerful, rewarding than being a mere member of Congress? I think that needs to be thought through. What is the proper training ground for becoming a president? I mean, is it a governor like Reagan, Bush, Clinton? Or is it being a senator? Why would you want to become president? What is the role of a president? And what, again, to repeat, what is a constitution supposed to do? It seems to me a constitution is supposed to outline a way of doing things. And that the way of doing things is to have competition between the branches and competition between the state and federal level. That too much cooperation leads to consolidation. And accepting, like the school lunch program, simply saying, well, it's about our kids, it's about the money, let's just do it. I am concerned that conservatives, who should be, in my opinion, constitutionalists, are becoming in many ways consequentialists. By which I mean they don't really care as much about the separation of powers as something to be protected, but rather win the presidency, put our people in it, and all will be well. And that bothers me, because it's mirroring what I see a number of progressives have done. That is, the separation of powers is old hat, is something that only was good for the 18th century with Newtons and systems holding in balance and Madisonian kind of astrology. And now we have enlightened administrators and the administrative state and coordinated government. And so such things are old-fashioned and anachronistic. In fact, we shouldn't really have the Senate anymore, because it means that Alaskans get the same representation as Californians. So I think the issue boils down to whether or not there is a role for constitutions and institutions in the fabric of American life, or are they simply 18th, 19th century anachronistic holdovers, and that we can just get on with the business of governing. And I would like to argue that there's still a human nature, and that human nature is fallen, and that we have to work with that, and that we simply cannot transform humans into angels or expect humans to act in some superhuman way, and that's utopia. And that you will be, and that is just, that's not what self-government is about. All right, and on that note, I've given us enough time, and I hope enough material that we can have 15, 17 minutes of final talk before we go goodbye. Never to see you again. Until next time. Yes.
Yes, thank you. Yes, on your comment about how things have changed since the time of FDR, can you maybe give us some background on how you see things going in the future? Will the justices be looking at the necessary and proper cause, the Commerce Clause, the 10th Amendment to interpret federal initiatives in the future that or controversial, such as the Affordable Health Care Act?
Well, you want me to focus particularly on the judiciary?
Yes. What do you think they will be looking at, and then what should we be looking at based on your premise that we should be looking at the Constitution itself rather than just the judiciary and outcomes?
Well, that's a very good question, and I will try my best not to get carried away and focus. I would say that it's, let us presume that the progressive agenda, which is essentially social justice, no one left behind. Democracy does not mean majority rule, it means everyone to have the same sort of guaranteed outcome, which is what FDR is sort of premising his Commonwealth Club speech, etc., which caught on with the American people in a great way, and 32, 34, 36. That's never happened before, and it's never happened since. The Great Society has not acquired that same status, and Obamacare has not acquired that same status of 3 straight victories at the polls. So there's something about the FDR and the New Deal of everyone transforming, the Enlightened administrator that has arrived in this country, which is very difficult to undo. Okay, that's my starting premise. At the heart of that success is the presidency, not Congress. It's the presidency, and declaring war on things, that politics becomes war, the metaphor of war, not deliberation. So we're entering not the founder's world where we deliberate and compromise. Rather, this is, it's very difficult to talk civilly if we're in war, where we're friends and enemies. So that's something that has happened, another thing that has happened. I think 1952, 1954 is one of the first times that the progressives really started embracing the judiciary. They went after the legislature and had a considerable amount of success between 1880 and, say, 1920 by painting the legislative branches in the pockets of the robber barons, of the few moneyed interests, and managed to suggest that we, at the state and local level, we have direct elections, referendums, and at the presidential election, we turn the governing of the country over to the president. The courts were not part of their favorite activity. The courts were looked upon as old men who represented the past. Roosevelt looked upon the court as a reactionary branch, the horse going in the opposite direction. So one of the interesting questions that you are raising, and I congratulate you, is I'll put it in my own terms. When did the progressives, the FDR types, post-FDR, when did they become attracted to the court? Because they're not naturally attracted to the court at all. The answer is Brown versus Board of Education. When the court decided in favor of racial integration in the schools. And very few people would argue against that decision. But it's the way the decision was made which opened the door. It opened the door to social science. It didn't open the door to constitutionalism. It was not decided primarily on constitutional grounds. It was decided on social science grounds that African Americans would feel slighted and belittled and antagonistic to learning simply because of segregation. So that they went beyond the Constitution in explaining the unconstitutionality of it. That's the danger of the court, where it decides to go, where it decides that what the Constitution is what we decide it to be. And therefore now we get social science coming in to help the court explain what needs to be done and what needs not to be done, rather than constitutionalism what we need to. That's what I say. We have justices now than we have judges.
Wasn't that overturning Plessy versus Ferguson? So weren't they overturning?
They could have done it on constitutional grounds. They interpreted the 14th Amendment through social science. They didn't interpret the 14th Amendment through through an understanding of, say, original intent of the 14th Amendment. This is the problem with constitutionalism. How do you interpret the Constitution? Do you rely on extra constitutional means to interpret the Constitution?
Well, I don't know. Can you tell me how would they have been able to use the Constitution to overturn Plessy versus Ferguson?
Well, how did they use the Constitution to introduce Plessy versus Ferguson? Plessy versus Ferguson overturned a whole bunch of congressional laws during Reconstruction and beyond, which introduced civil rights in the 1870s and 1880s. Plessy versus Ferguson was a court decision which we, the people, simply said, well, I guess the court has decided. The court decided, and here's the point. Can the court make a mistake?
Of course.
Oh, how do we know?
Well, we find out when we object and we...
Well, all right, so do we have grounds to object to the court?
When you say, do we have grounds? Of course we
Well, all right, so, all right, I'll take the heat off. I think the court made a mistake in Dred Scott, right? I think it went beyond constitutionalism. I think it decided that Dred Scott didn't have standing because he was an African American, and African American with second-class citizens proof because they couldn't own guns or interracially married. Therefore, Dred Scott did not have standing. African Americans at that particular time, 13 to 14% were free. Not a high enough number for me, but 13 to 14% were free, and they were voting, and you can't vote unless you're a citizen. They were voting in Massachusetts, etc. So what Dred Scott decision is that it went beyond the Constitution into early social science, looking at societal frameworks, read that back into the Constitution to declare something unconstitutional.
Didn't this all start with during the Abraham Lincoln era when they made a big, you're the expert.
No. I'm a citizen who wants to know about the Constitution. This is the point. Constitution belongs to us, not experts.
But the 13th, 14th, and 15th
Yes.
Amendments chart whole new direction for the Constitution. So
Undoubtedly.
So are these decisions kind of tied in, Plessy versus Ferguson and so forth? Are they all part of a continuum and therefore?
You could say that, but I wouldn't. I would say if you take a look at the 13th, 14th, and 15th Amendment, the context was to incorporate African Americans within the system that was formally open to African Americans only in certain states. I mean, one could say, did African Americans have the right to vote before the 15th Amendment? And the inclination of students is to say, no, they didn't. That's what the 15th Amendment did. 15th Amendment didn't do that. 15th Amendment, African Americans could vote in certain states before the 15th Amendment. What the 15th Amendment says is no state hereafter shall deny. Right? Could women vote before the 19th Amendment?
Yes, they could.
Yeah, that's right, but we tend to forget that. We tend to say, are you telling me that the right of a woman to vote depends upon the mere accident of where she was born or lived? And I will say yes. And the answer would be, well, that sounds undemocratic to me, to which I say, how federal? Can you tell me that 18-year-olds couldn't vote before the amendment in 1972?
Of course they could.
You got it. Of course they could. So they could vote in Hawaii. So
We have the 10th Amendment.
All right, we have the 10th Amendment, but all right, now I try to remove the heat from you.
Oh, no, okay, I back off.
Right? But if you want the heat moved back, I can do it.
The expert. You are the
No, I don't want to be the expert. But you're lobbing me material, and unfortunately I think upon myself from time to time as an academic comedian. Therefore, when lobbed material goes my way, I say I don't have to work for the next joke, but I let you off.
Go ahead.
Because I'm a decent man.
Thank you.
What does the 10th Amendment say?
Those powers that the federal government doesn't have by virtue of the Constitution are reserved to the states. Am I correct?
No.
Okay.
Or to the people. And you nearly said, of course, which is what I wanted you to say, so I could go tee-hee, and come at you. You nearly said the power is not expressly granted to the federal government. I think that's what you meant.
Actually, what I meant was that the states have a lot of power, and
But that's, yeah, all right, so I don't deny that. But what I thought you were going to say, what I hope you were going to say, was that the powers not expressly granted to the federal government are reserved to the states. Of course, the word expressly is expressly omitted. So the debate continues. The 10th Amendment does not settle the issue.
no, I thought that's how the first 10 states to give women the right to vote were all west of the Mississippi. And
That is correct.
And I thought that was by virtue of the 10th Amendment.
No, it wasn't. Well, it could, maybe the 10th Amendment was used, but it's really by Article 1, Section 2, which decides. Article 1, Section 2 leaves it up to each state to determine the right to vote for Congress and for the president. If you have the right to vote in the first branch of the state legislature, in your state, you have the right to vote in Congress. Why did they decide on that? Because some states said we should make freeholding, which means you own your property free of mortgage or free of debt. We should make that. Why? Because that would mean that you're not beholden to any politician who's going to promise you money and whatnot because you're an independent operative. And others from Virginia said, well, in Virginia right now, mechanics can vote, but you ain't going to really call their tools property. So that we will have this strange situation where mechanics can't vote in Congress if you have freeholding, but mechanics can vote in Virginia because we don't have a freeholding law. So what the convention, the framers decided is, we leave it up to each state to determine. That is, if you can vote in the most democratic branch in your state, then you can vote for Congress.
But that didn't affect the first states that gave women the right to vote. Because in the first place, it was Wyoming. Wyoming wasn't covered, right? You tell me, because it was a territory, right? But they were able to come in.
Well, I think there are two things. One, Congress controls the territory and can decide, leave that up to each state. I don't think the 10th Amendment, see, if you're saying that Wyoming is a territory, then you can't argue 10th Amendment, because 10th Amendment only pertains to a state.
Then would you be able to argue that first Article 1, Section 8? I don't know. I'm asking you. You're the expert.
You keep saying that, you keep proving me wrong. No, I would argue that see, there has to be a tradition behind constitutional understanding, right? The tradition is the right to vote, unless otherwise specified specifically to the contrary, depends upon it depends upon the state in which you live. We have made specific statements which alter that. 15th Amendment. So that prior to the 15th Amendment, it depended on which state you resided as to whether or not, if you're an African American, you could vote. Prior to the 19th Amendment, which specifically articulates that a state can no longer decide this issue of whether, if to give women a right to vote or not. How about the 18th Amendment, my favorite?
That's the one that was changed, right?
Well, you know what? What surprises me? It's the only amendment which has been changed, and yet it's probably one of the least amendments that's been studied. I mean, think about what that means for America. America very rarely amends and has never re-amended. That is worthy of a huge study. But look at the 18th. Prior to the 18th Amendment, could there be prohibition on alcohol, on the consumption of intoxicating liquor?
Yes.
Right. What does the 18th Amendment do?
Makes it national.
Makes it national. That's right. That's what prohibition is. It makes it national. No state. Right? So what does the overturning prohibition do? That's right. All you have to do is travel, which I do, and have Sunday travel, which I have done a lot of. And you go to an airport, which I'm always at, and I am fascinated by the variety of drinking laws. Right. 2 weeks ago, I was in Cleveland, and I'm a member of the United Club because I've done 2 million miles. All right. This is a private club. You pay membership. You're not buying a drink. You can only, I don't want to, I'm saying, because I'm curious, and I'm bringing out the point. If you're in United Club in Cleveland, and you happen to be 7:30, 8 o'clock in the morning on a Sunday, you can drink beer, but you can't drink anything else until 10. If you were in Chicago until a year ago, before noon on a Sunday, you can't drink anything in a private club. Still today, in a private club in Dallas-Fort Worth Airport, you cannot have a drink, alcoholic beverage or intoxicating liquor, not even sacramental wine, before noon. You can have food.
With your liquor.
But no, not at Dallas-Fort Worth. Not in the private, no, you cannot. So the point is, we can stand, somehow we can live with that diversity when it comes to alcohol, right? We cannot live apparently anymore with that diversity when it comes to cigarette smoking. We cannot live with that, that's what I'm getting at, right? The institution of federalism permits diversity. So you have to ask yourself a question. To what extent am I a Virginian or American when it comes to the following? What if my neighbor believes in 3 gods and has 2 wives? Does it matter to me? All right. No, it doesn't matter to me, as long as he's having the 3 gods at the same time. No, it doesn't matter to me. Okay? Well, how about if I say, what if my neighbor has 3 slaves? Should that matter to me? The answer to me is yes. What if my neighbor has 1 abortion, or 2 abortions, or 3 abortions, or 10 abortions? Does that matter to me? This is the issue. How much diversity are conservatives willing to put up with, and how much conformity are liberals, progressives insisting on? It seems to me the progressives today are insisting on an incredible amount of diversity when it comes to school lunches and on cigarette smoking. They permit all kinds of things sexually in Hollywood, but you cannot smoke after sex. I have neither. I'm a monk. I will say anything to get a laugh, you know that. Last question.
Oh, I was just going to comment that the diversity, the issue of accepting things, how much diversity that I, as a self-admitted conservative, will accept has to do with how much tax money you're going to extract from me in order to pay for the things that you want me to conform to. Because if you're asking me how many abortions my neighbor has and how does it matter to me, it matters to me if my tax dollars are paying for it.
Okay, and it doesn't matter to you if your tax dollars are
It
not...
matters to me morally, but when you're talking about how much diversity I'm willing to tolerate in a civic sense, then the issue comes down to who is paying for it.
Okay, well, let's take the money issue out of it. We've got a private donor who has lots of money, and you won't be touched at all. You don't have to pay any taxes. Does it still matter to you whether your neighbor has 1 abortion, 0 abortions, 1 abortion, or 5 abortions?
It matters to me morally, for sure, and I would...
Okay, so what do we do about it?
It's a personal persuasion, matter of personal persuasion, I think. We have to
All
change
right.
people's hearts.
I turn to you and I say to you, we're all Americans. If that woman were living in Alaska, she could have an abortion for free, but living next to each other and wherever it is that we're living next to, she cannot. So you're going to tell me she has to move to Alaska?
How very federal.
You've got it! That's the perfect answer. That is the perfect answer. Are we a national democracy with one standard that fits all? Or are we a federal republic in which an institutional separation of powers and separation of A division of powers matters. That is the issue. The last 100 years has been a march towards more national and national democracy. And the latest, the latest sort of poster boy, child, whatever it is in this debate is the Electoral College. It's being described as undemocratic by the National Democrats and as states' rights by the federal Republicans. And that is the issue. So I pose it in the sense that, borrowing from Thomas Jefferson, when asked, what is the role of government? I mean, that's what we're looking at when we ask the question, constitutionalists, what is the role of government? And Jefferson would say, well, I'll tell you what the role of government is by asking the following, by posing the following statement. Should government get involved in the following issue? My neighbor believes in one God or 10 gods. Should the government get involved in standardizing the number of gods my neighbor should believe in? And Jefferson says, no, that's not the job of government. The job of government is to stop my neighbor from picking my pocket and breaking my leg. Okay, so now I am expanding that question and saying, well, does it matter whether my neighbor has 1 abortion or 10 abortions? And if I'm a Jeffersonian, I guess, this is what I'm getting at, the answer would be no, as long as my neighbor doesn't pick my pocket or break my leg. Well, should I be concerned with whether my neighbor has 1 slave, no slaves, 1 slave, or 10 slaves? And I'm going to break the Jeffersonian mold and say yes. And then I have to answer why I'm not willing to put up with that diversity about slaves, but I am willing to put up with the fact that they can have an abortion and they can believe in one God or have 2 wives. I mean, why do I draw the line on slavery? So I think we all have to ask that question. I've made myself very vulnerable. I have to now defend why I will not accept diversity in slavery.
13th Amendment.
What?
13th Amendment.
I can overturn it. We overturned the 18th. Why can't we overturn it? But you're correct, because we have the 13th Amendment. So now I object, let's overturn this. If I could get would you join? No, you see, you wouldn't join. And I hope you wouldn't join a movement to overturn the 13th Amendment. That's one reason why we amend. But look at the double-edged sword of amendments. Amendments say we are hereby going to make it more difficult in the future. Not impossible, because the Prohibition Amendment was overturned. But hereby we're going to make it more difficult than a mere statute. A constitution is not a statute. So we're going to make it more difficult to overturn. Why? Because what the experience we've been through. But you know what we're also saying to the next generation? We know better than you do on this issue. That's a heck of a thing to say to the next generation. But of course the next generation can say that we're wrong. And the next generation did say that we were wrong about the 18th Amendment. So if I were to come back to a point you've made earlier about the court, I would say that we live under a constitution, but the constitution in the end is not what the court says it is. The Constitution is what the amendment process says it is. Because the 13th, 14th, and 15th Amendment were overturning a Supreme Court decision. They overturned, 13, 14, and 15 overturned Dred Scott. Can a court be wrong? Yes. How do you correct the court's decision? By amendment, or impeach them. Or, nowadays, just wait their turn and replace them. But then that's really FDR was not the first to want to stack the court. Lincoln did. At one time we had 7 Supreme Court justices. Then we had 9 through when they had territorial expansion. The number 9 has only remained, quote, sacrosanct, unquote, since Grant. Lincoln asked for an increase from Congress to make sure that there would be no more Dred Scott decisions. He was granted. He was allowed by Congress to nominate more than 9.
I'm curious, now, a historical point. Did that follow Buchanan, the guy that was the president
Yeah.
before Lincoln? Was it true that Buchanan interfered with the Supreme Court and was trying to influence it to judge, to make the Dred Scott decision, or is that?
That's Lincoln's point.
Is that the truth? Is
That's
that
it.
why?
There is some evidence to indicate that the court could have decided the Dred Scott decision before 1857, but there was an understanding between various actors that it should be postponed until after the election.
Is it true that Buchanan tampered with the Supreme Court?
I don't know about tampering. But there was See, the separation of powers did not necessarily mean no one from one branch can talk to another. But it means the amount to what is the opposite of tampering would seem to be independence, right? But how independent? I'll give you another example, which is not very well looked at. The Supreme Court was going to make 2 decisions during World War II about Japanese internment. One we hear about, the other one we don't hear about. We hear about Karematsu. We don't hear about the other one. Both came down on the same day. There were discussions between the court, representatives, and the White House. And the decision was FDR would have his way on Karematsu, but would lose on the other one. And the very next day, FDR would declare the internment camps closed. Did they talk to each other? Yes. Was it tampering? No. Is that independence? Not completely. Was a crisis avoided? They thought so. And I think it's the same reason that Buchanan intervened. Presidents from the 1830s, 40s, 50s, their leadership on slavery and secession was leave things alone. Abolitionists go home, anti-abolitionists shut up. Leave it alone. That was the core of their presidential leadership. And so part of that was, court, don't take this on. In fact, it was the abolitionist lawyers who pushed the Dred Scott case. There's a lot of very interesting stuff around. I don't know if it's tampering. I wouldn't go so far as to say tampering. Lincoln certainly presented it as some kind of, shall we say, collusion. And yeah, there's been collusions over the years. Yes. All right, last question. Yeah, go ahead.
Quick question. Do you
Yeah.
think there was tampering in the case of deciding Obamacare at the Supreme Court?
No. Foolishness, but not tampering. I think Roberts tried to be an enlightened conservative and thinking he was a statesman. And I don't think that the job of a judge is to provide the argument for the administration as to how they could get something passed. He was not presented primarily with the taxing power. He was presented with interstate commerce. He should have decided on that ground. So I don't think it was tampering. I just think it's yet another example of justices or judges thinking that they're so important that they're going to save the country from themselves. I think Gore versus Bush, that should have ended up in Congress. Oh, but it's too dirty. We don't know what we're doing. We are the court. We have to give the final decision, right? That's what's happening with the court. They think that they're the final arbiter of the Constitution. We are. But we can't do it if we're not educated. And we can't do it, with all due respect, if we must defer to experts.
I'm looking to you for information.
That is great. I'm glad you're not looking for me for transformation. Well, thank you very much indeed for coming.